Happy New Year. Every Tuesday, Reddy Neumann PC does bring in immigration updates. Along with me is my business partner, Emily Neumann. Emily, what do we have today for discussing?
Yeah, Happy New Year, everyone. Glad to be back and ready to get started on this new year. Today, we want to start off talking about things we're seeing in the Chicago airport. We're actually seeing cases of people coming in on H-1B or on F-1 and getting deported from the airport. It's called expedited removal. This tends to happen in Chicago. So we'll talk about what are kind of the common themes that we're seeing with that, what causes it, what to be aware of, and what you can do if you're in that situation. We'll also be talking about the latest on PERM processing times. What are the current trends, how long it's taking to get prevailing wages, and how long to get the PERM approved, and what options you have for extending your H-1B when your PERM is pending for a year. We'll also be talking about a very common question that we get is, what do I do about traffic violations? What is the impact on your visa status? How does that impact travel plans? When do you need to worry about it, and when do you need to disclose it? And then lastly, eligibility for EB1C is, as we know, the EB2 and EB3 dates are not going to be getting better anytime soon without change either from the administration or from Congress. So what are your options to go back and work abroad as a manager for 1 year in order to come back and qualify in the EB1C category and port your priority date from your old EB2 or EB3?
Emily, I'm getting a lot of reports from the Chicago airport. I've had a lot of consultations, people calling us for the free conference calls. And of course, I get the middle of the night calls from these community organization presidents, vice presidents, and some of the company owners calling me in the middle of the night. Of course, most of these people have my cell phone access. In fact, on 31st night or first morning also, I got a couple of calls. Sorry, I had some drinks on 31st. Sorry, so I wasn't able to take the call. Sometimes it happens with me, especially in the middle of night at 1 o'clock or 2 o'clock. Sometimes I don't. Sorry about that. But I'm getting a lot of these calls from Chicago airport where people are getting deported, Emily. Now, I will tell you the reasons why these people are getting deported, and then you tell how they are able to get these people, first of all. I've had people where there was some issue on the resume part of it about 4 or 5 years ago when he got a job for his first job. Seems that in the WhatsApp application, when they searched it, there is a word called proxy. That means either this guy is helping somebody or he took a help of somebody, or at least that's an acquisition that they're having. There are people who are coming for the first time into United States, especially for this January semester, though. There are some issues with them where there was some WhatsApp messages between them and then friends that as soon as they come here, they do join in a restaurant working not legally in the United States when they come in. I also had issues with regards to people who had a lot of gaps in the employments on OPT and STEM extension that got deported, and some issues with the Day 1 CPT universities also recently in Chicago airport. All this happened in the past 10 days. There's a lot more scrutiny. Now, there are some other airports that I got complained recently, one in San Diego, and I don't remember the other airport, though. But most of the complaints that I get it are from Chicago airport. And this is probably the third or fourth session that we're putting a title that Chicago airport is a troublesome thing. So how do they catch these people? What is the criteria for the CBP for them to check the WhatsApp messages? One person who was coming after visiting India, he was in student visa here, he showed some bank statements where there was some cash getting deposited. He explained to them that it was the rent that he collected from the other people in the roommate. Like, for example, I think so he said there are 4 people that stay in the apartment, and then he pays the rent, he collects the money. But it seems that the money was getting deposited every week, certain cash was getting deposited. And that was, and they asked many questions. He couldn't answer the questions. They were accusing him that he worked in a restaurant and he was getting the money, and that was a cash deposit there. How do they, is there a criteria for CBP to catch? How do they catch them?
Yeah, they, as you're an immigrant coming into the U.S. at the airport, you're not technically on U.S. soil until you make it through all of the customs and immigration and all of that. So you don't have as many rights at that point when you're at the airport. So most of this is coming from your cell phone. And when you are referred to that secondary inspection, many times they will ask to see your cell phone, even if it's got a password on it. They're going to ask you to unlock it for them. If you use WhatsApp, they're going to ask you to open that, even though everything's encrypted, so that they can review everything. And they'll, make you sit there for hours on end, make you scared and nervous, and tell you they're not going to let you into the country until you let them have access to your phone, your email, your bank statements. I mean, everything's in your phone. So that's definitely where they're getting that information from. And they definitely seem to have these buzzwords that they're looking for, anything related to some kind of work. If you're coming in on a student visa and you don't have OPT, any conversations about, hey, can you help me find a job? Or, hey, I'm looking for something to make some money. And of course, seeing bank statements or seeing, Apple Pay or Zelle transfers happening on a consistent basis is going to call into question what that money is for. And as you mentioned, the resume, if you've got an old copy of a resume from your email from 4 years ago, they're looking at those attachments and comparing it with your immigration background and saying, hey, this resume looks like it's inflated. We think you used a fake resume to get this U.S. job. And that word proxy, people, we're aware of job interviews, especially when everything's remote nowadays. If you're doing a remote interview, maybe you have someone else do the interview for you, or you are doing the interview for someone else to try to get that job. All of those things are in your phone, and CBP can access to them, and you have no right really to block them from accessing it. If you say no, they'll just tell you that they're not going to let you into the country. So what should you do if you're in that situation? We see where, you've been waiting hours and hours. You're willing to say anything just to get out of there. But what if they have it wrong? What if CBP gets the wrong conclusion? Should you just keep quiet and be sent back, or do you say something?
You have to raise your hand, and I respectfully disagree with the officer, because they're writing the notes and giving it to you at that point of time. You have to voice it. I respectfully disagree with the statement which is written here. This is completely contradictory to what I state. If you disagree with any of the statement, what you have given and what they are showing it to you, if you disagree with, make a very good point. Officer, I want this to be on the record so that I have expressed this one. You may disagree, but I want it to be on the record. Emily, one thing in Chicago airport, though, when people are getting deported, though, they are supposed to give the written statement of what the officer has recorded the conversation between the particular H-1B or F-1 person and the officer. And I have noticed that in some cases, especially in Chicago airport, they don't give that notice. So when you're getting deported, you need to request the officer. If the officer is telling, I'm denying your entry, or if the officer is giving you an option of request a withdrawal of your entry into the United States, have them give the written statement, what they have recorded. They do request them. If the officer is not willing to give request, I want to speak with the supervisor because my lawyer told me I'm supposed to get a written statement when I am sent back to my home country. Please, I need to have it for record so that later on my lawyers can review it to advise me properly, and if needed to go to the court case or probably apply for a waiver case. You need to have that one. You need to request that one. Another suggestion that I would always tell people is that, hey, have your friend search for your phone. I mean, if you can have the immigration, you don't have an option to have immigration officer doing it. Have some very naughty, very bad friend of you review it. let him see what he finds out in that phone. I mean, that's probably something that you have to do, because if there is something that is problematic thing, maybe you should discuss with a lawyer. You don't want to be in the airport. The problem is in the airport, you don't have a legal rights to get a lawyer there to be present or be available for you to help you at that point of time. So it's better to have it done before if you have any doubts. And by all means, if you can avoid Chicago Airport, if you have any scintilla of doubts, just step away. Don't get to Chicago Airport. I don't want to get a midnight call, please. Anything else, Emily?
Nope, we can move on to PERM, processing times. What are the latest trends? So prevailing wages, we're still seeing 5 to 6 months to receive those. What are we seeing in terms of PERM approvals right now?
We're seeing November and December, Emily, at this point of time. A lot of people are asking, have we seen anything that was filed in January of 2023? I haven't seen yet the January of 2023. What is the solution, Emily? If the labor certification is pending, I know that if the I-1, everybody knows that if the I-140 is approved, which most of our guys are going to do premium processing of I-140 approval, they get a 3-year H-1B extension. What is this 1-year extension? Under what circumstances we can do that 1-year extension?
Yeah, so if by the time you're reaching your 6-year limit of H-1B, your PERM has been pending for at least 365 days, then you're eligible for a 7th year extension. So you get a 1-year extension instead of the typical 3-year extension. So by the time your 6-year limit hits, has your PERM been pending for 365 days? If the answer is yes, you can get an additional extension while you're waiting for that PERM to be processed. And that also works, yes.
Emily, I have a question. So let's say, for example, my H-1B is expiring in February of 2024, but my 6th year is expiring in April of 2024. My labor certification has been filed in March of 2023. Can I now apply until April of 2024 because I'm entitled to, because it's within 6 years, plus 1 year of the extension based on the labor certification filed in March? And can I do that in January, or should I have to wait until March?
The good thing is, yes, you can do that, and you don't have to wait until it actually hits 365 days. So basically, you can do your extension from February to April to get the remainder of your 6 years that you have available. And then because by April, your PERM will have been pending for 365 days by that point, even though today in January it has not been pending for 365 days yet, but it will have by the time your 6-year limit is reached in April. You can add that additional 1-year extension, and you can combine those 2 extension requests in one petition. There's an old AC-21 memo from 2010, maybe even before that. It's a very old memo, but it's still good law, and we do that quite often. Never had a problem with that. So you definitely want to take advantage of that, especially if you're in this, a lot of people, I feel like, want to wait until the last minute to see if maybe they can get their I-140 approved to get the 3-year extension, which is great. But now that we know these processing times are 11 to 12 months, it may make more sense to go ahead and get your remainder of your 6-year limit and get that 7th year extension now in place, so that you have time to get the PERM and I-140 approved by the time of your next extension over a year from now.
Emily, there are some situations where people come across where the I-140 gets denied. Can we just file an appeal and then extend the H-1B by 1 year?
Yes. So if you're, obviously having the approved I-140 is the easiest because you get the 3-year extension. But if at the time the I-140 gets denied, most likely you've had a PERM pending for 365 days, or the PERM plus the time the I-140 was pending is more than 365 days, but your I-140 gets denied, you can file an appeal of that I-140, and then that I-140 is considered to be pending. as if it was never denied. So we go back from the day the labor was filed all the way till now that we have an appeal pending. And if that adds up to 365 days, that allows you to file an extension now based on an appeal. So an appeal as treated as if a final decision has not been made. You just need to make sure that you get it filed and get the receipt notice, and you utilize your labor approval notice plus your I-140 receipt notice plus your I-290B receipt notice to document that it's been pending, meets that 365-day requirement.
Anything else, Emily, before I go to the next topic?
What do we look for going forward in PERM processing times? Is there any chance things might get better? I don't see it. We did get some recent data. DOL is dealing with a 10% increase in prevailing wage requests, a 12% increase in PERM filings. And they did get a $2 million funding increase for the fiscal year, but due to inflation, they're claiming that that's practically useless. So they've not really been able to address any of these increases with additional staff. They're constantly having to move resources around to deal with the H-2A and H-2B peak seasons and all of those filings because they have very specific deadlines. So it doesn't look like things are going to get any better anytime soon. So just a reminder, as always, you should be starting your PERM process at least 2 years before your 6-year limit is going to be reached.
They would have given that out of the $2 million, $1 million to one of our nice H-1B guys. They would have programmed the system much better and removed a lot of stuff and saved a lot of money, and then would have decreased the timing by about 75%. Their system is wrong, Emily. Anyway, yeah. But I want people to be prepared that the labor certification is going to take a long time. You need to be prepared to file the labor certification as early as possible, prevailing wage as early as possible, PERM as early as possible, and be prepared to extend the H-1B. Don't wait for the labor certification approval and then go out of status, okay? Just file the H-1B extension for 1 year, as Emily has pointed out. Traffic violations. We're only speaking of simple traffic violations, guys, here, where you have you have done some speeding, maybe you have gone in the school zone at 20 miles, you've driven at 31 miles. Is there a stop sign? You violated it. Those kind of traffic violations, people come panicked. Oh, it's a crime, it's a misdemeanor. Guys, of course, we want you to take care of the traffic ticket. Either you challenge it in the court or you pay the fine. We are not the traffic lawyers. However you take care of it, once you take care of it, it's been resolved. It can be resolved either of the 3 ways. Dismissed because you went to the court. Second, you do some defensive driving or something and then take it off. Third, you pay the penalty, whatever the penalty they pay. Now, this is not going to cause any problems for you in getting your visa stamping. This is not going to cause you any problem in your travel. This is not going to cause you any problem in the coming into United States, in filing the adjustment of status. And you don't have to report it. Now, this is where the problem comes in. When you guys report it, this one, the traffic violation, especially in the DS-160 form, N-400 citizenship form, or the green card form, they get confused about it. Why is this guy getting reported? They think so that maybe you have something more than this just mere traffic ticket of $400. And that's the reason why you guys may get into trouble. If the traffic ticket is less than $500, no bodily injury involved in it, and just a regular traffic ticket, not a DUI, okay? DUI you're supposed to report. No arrest has been made. You do not have to report it. And by reporting it, you're going to create a trouble. Especially in the N-400 form and also in the I-485 form. In the instructions clearly mentioned, you don't have to report this one to the USCIS. So please don't report this minor traffic. If it's a major one, where is something more than $500 fine, or definitely DUIs have to be informed. And but minor traffic violations, you don't have to worry about it. You don't have to inform the DS1, have you charged with any crime? Technically, it may be a crime, but they don't want you to report these things and confuse them, guys.
Yeah, and as we were preparing for today's session, I just Googled, should I report a minor traffic violation? And I pulled up so many different lawyer websites that said, yes, although it says you don't have to, you still should report it to cover all your bases, just so it doesn't look like you're covering anything up or misrepresenting. So there's definitely a lot of misinformation out there, a lot of people that are maybe overly cautious, providing bad advice, really, because it's not required for you to report that. And it actually probably causes more confusion than it helps.
Anything else, Emily? On the EB1C eligibility, though, a lot of people are opting right now. It may be a good option. You may think into it if you have an EB2, EB3, and you're contemplating on moving into EB1C category. There are a couple of things that I want you to note it down is that it must be a high-level manager, not that you're just managing 2-3 people. And most of your job duties are involved into day-to-day work, and then you're having, let's say, 10%, 15% of your duties are devoted to the management of the people, though. It may not be enough at all for you to get the EB1C. So before you embark on the journey, though, try to secure a better position. Where you will be involved in manager level, higher level manager. And most of your job duties should be involved in managing people. That's one thing that I want you to look into. But people ask me this question, if I try EB1C, if I fail in EB1C, what will happen to my EB2? It will remain as it is. It's not going to go anywhere. You will still have the priority date. Your EB2 I-140 is still alive. It doesn't die. So you can take a risk at it. If it doesn't work, you're still in EB2.
Yeah, and I've come across the situation where people, maybe came into the U.S. on an L-1B and then later converted to an L-1A and ended up, their company filed an EB2 or EB3 because the foreign position was disclosed as specialized knowledge, not manager or executive. So to qualify for EB1C, your position outside the U.S. had to also be manager or executive. So specialized knowledge doesn't work for that. And that's where it gets a little trickier because if you mentioned everything about the foreign position as being specialized knowledge, but now you're saying, oh, wait, it was also a manager position, you've really got to look at everything that was submitted about that foreign position up till this point, because it's very likely that a job description's been submitted for your initial L1B, for all of your L1 extensions. In your PERM filing, there's going to be a job description there. So if in all of those job descriptions, there's never been any mention of you being a manager or having managerial duties or supervising people or hire, fire, or anything like that, there's some risk there that they could think that you're now misrepresenting what the foreign position was, or if you're not now misrepresenting it, maybe you misrepresented it previously, and by not explaining exactly what the position was. And that can sometimes lead to a problem with the already approved EB2 or EB3. So if you are using experience that you already had, make sure whatever you're submitting now lines up with everything that was previously submitted. I think more commonly we're seeing people going back outside the U.S. working for 1 year now and then coming in to qualify for EB1C. That's a much cleaner case because you're not relying on your prior experience outside the U.S. You're using experience now. So now the purpose, you want to make sure that the position actually qualifies. So what is exactly qualifies as a manager? Number one, you've got to actually manage a component of the organization, whether it's a department, a division, it can even be a function of the company, but there's got to be some set structure where you manage that part of the company. You've got to actually spend the majority of your time supervising and controlling the work of other people. And those other people either need to be supervisors or managers themselves, or they need to be professional level, meaning that the people you're supervising also hold bachelor's degrees. And that documentation often has to be submitted. Then you've got to show that you actually have the authority to hire, to fire, to give promotions, or at least to recommend promotions or give leave and those sort of things, and that you exercise discretion over your particular part of the company. It takes a lot of documentation, organizational chart, as I mentioned, education documents of the subordinates that reported to you, pay records to show those subordinates are actually employed by the company, and then a lot of email communications to show you actually carrying out your managerial responsibilities. Performance reviews, those are a great set of documents to submit because that shows that you're responsible for reviewing someone else's performance. So you need to make sure whatever you do before you embark on, this new job abroad to try to qualify for EB1C, make sure that job actually is going to qualify at the end of it. But as Rahul said, if it doesn't, your EB2, your EB3 is still intact as long as the company is still offering that position going forward.
I have some interesting question on this EB1C category. This gentleman, family fun time videos. He's an H-1B and he's trying to now go and work in India for 1 year. And he's asking the question, can his spouse, who is an H4, stay in United States? He still has 2.5 years of H-1B left. And his kids are US citizens. Can his wife stay in H4 visa and study in the United States? The answer is no. Because if you are going to India or any other country for working, you're not maintaining the H-1B. You're not only maintaining the H-1B, you're on the payroll of the other country's H-1B. Because you're on the payroll of the other countries of your company, though. And because you need that for the EB1C requirement. If you're working there, you must be on the payroll of the company. So definitely, she cannot stay here on H4. You can do one thing. If she's studying, convert her to F1. She can stay here in F1, and your children are US citizens. They are free to do whatever they want to.
Pakala says, my EAD extension has been approved, but the AP is stuck. Is it worth refiling the EAD AP with the new approved EAD card to request the combo card? Are there any pitfalls? I don't know if it's worth it. I've definitely refiled an AP when we were seeing a lot faster processing times. And now I have 2 pending APs that have been stuck. So I don't know how helpful it actually is. And I don't know if I would refile the EAD along with it. I'm not really seeing much benefit to doing that because they're probably just going to deny that I-765 saying, we already gave you an EAD, you don't need another one. But I've tried it, and so far, both APs are still pending.
Vishal has this interesting question. He's an L visa. His L visa is expiring in December of 2025. His passport is expiring in January of 2026. Now, what he's worried about is that, can he extend the L visa for a period of time which he's authorized, either 2 years or 3 years, depending on whether he's an L1 or L1A or L1B, even though his passport is expiring in January of 2026? The answer is very simple here. The passport must be valid at the time you are filing the extension. So if you're filing the extension from December of 2015 to December of 2025 to December of 2028, your passport doesn't have to be valid until December of 2028. It should only be valid at the time of filing. Let's say, for example, you're filing in July of 2025 extension of your L visa, though. Or if in July, or let's say, for example, your passport is only valid in August of 2025, and you're filing in July of 2025, you're perfectly all right. You can file the extension. The passport has to be valid. Now, this is quite different than what we have been telling, though, on a very different issue than this one, though. Especially when you're traveling outside the country and coming back, your I-94 may be shortened up. For example, in this particular case, your H1, your L1 is expiring in December of 2025, and you applied in July, got the L1 extended until December of 2028. When you travel to India, even though they will give you stamping until 2028, when you travel back into United States, they may cut short your I-94 until January 2026. That means that you will go out of status or unlawfully present in January of 2026. So when you travel, it's a different role. When you are in United States, when you're extending your visa status in United States. Your passport need only be valid on the day of filing the extension, not until what you're requesting for.
JB27 says, when can we know whether the new H-1B lottery rules are going to be implemented for this year or not? This is dealing with the duplicate filing, changing how the lottery is done, and the increase in the lottery registration fee to $200. I would expect we're going to have to know by the end of this month, because typically when a regulation is published, it takes effect 60 days after the date it's published. And because the lottery typically happens starting the registration window around March 15th, that means January 15th is when this regulation would have to be published so that it can take effect in time for this year's lottery. I'm not holding my breath that it's going to happen. I think we might have to deal with one more crazy lottery this year, but hopefully they do implement it in time.
U.S. immigrant, do you have an EB1 free evaluation? Unfortunately, we don't. I mean, we do consultations because that's a part which is needed. We do a lot of consultations. When we do consultations, we have to go in depth for the EB1A. It's not like 1 or 2 minutes evaluation. It's not 5 minutes evaluation. It has to, and what we normally tell people for EB1 evaluation is we give them a video to watch. We give them the 10 points. We request them to jot down which of those 10 points they think they're eligible. We want them to give a resume that is custom made for EB1 and give any external link. And our lawyers will go through all those things. And, we do not have free evaluation for it, unfortunately. There is a Hindi movie dialogue, जब दन्नू घास से प्यार करती है तो खाएगी क्या? So that's a part of it. We need to have a consultation fees for it, unfortunately. But we do give very good evaluation. We are very proud of it. We're getting very good EB1 approvals right now. Not every case that we evaluate it, we take it. Not every case that comes in, they give it to us. They may go outside, or we may not feel comfortable taking on the case, but we give a very honest opinion on EB1 evaluation.
Srini says, I have a pending I-485 in EB2 with a priority date of May 2012. Now the date is current in EB3. Can I interfile in EB3, or would it be a downgrade? So if you don't already have an EB3 I-140 approval, you cannot interfile to EB3 to take advantage of the EB3 priority date. You would have to have your company file a downgrade. And the downgrade is not that difficult of a process. I-140 was approved till now. Once that's approved, then you can ask USCIS to transfer the underlying basis of your pending EB2 485 to the newly approved EB3 downgrade.
Shreyas Raut has this question. My cousin is applying for L1 visa. Is his wife eligible to work in United States? Simply, yes. The L1 visa dependents are called L2 visas. Either it's L1A or L1B, both of the spouses. Either of those things poses, we call them as L2 visa holders. These spouses are eligible to work and they don't need any work permit. When they get the visa, when they come into United States, they will get L1BS, and that's it. They can start work. L2S, sorry. And they can start working. No EAD required. They have automatic work permit. That's a very good thing.
Question from YouTube. I have an H1 visa with company A that's valid till 2025, but I'm working at company B based on a pending transfer. Now I got an offer from company C. Can I do an H-1B transfer to company C now? Yes, you technically can. So you would need to provide company A's approval notice, company B's receipt notice, and then you file a transfer to company C. You are eligible to start working for company C as soon as that transfer is filed, but there is a slight risk here. Once you join company C, if you leave company B while that H-1B is still pending, they may withdraw it, or if there's an RFE on it, they may choose not to respond it, and you could end up with a denial of that company B's transfer And if that happens before company C's H-1B is approved, you might have an issue, or sometimes USCIS might send a request for evidence on company C's transfer asking for what is the proof of the approval of company B's transfer. So yes, you can do it. You can lawfully work for company C as soon as it's filed, but sometimes it can lead to difficulties later on if something goes wrong with the company B petition after you've now joined company C.
Our immigration law, I have a GC EAD. That means I'm assuming 485 EAD.
Ratchet says, can I travel while the existing H-1B, H-4, and H-4 EAD applications are pending? What if the renewal applications got approved while I was out of the country? So number one, I want to make sure that these are all extensions. There's no change of status involved. So assuming all of these are extension applications, technically, yes, you can exit the country while they're pending and they will still be processed. The issue is coming back. So if you are planning to come back before they get approved, then you're going to have an issue with different I-94 numbers, because when you re-enter, you're going to get a new number, but your H-1B and H-4 extensions are going to be approved with the old number that you submitted on that petition. That can sometimes create issues for getting your driver's license renewal because of the issues with the save system, the databases that all talk to each other. So if you're planning to come back before it gets approved based on your visa that you already have, I generally would recommend going and coming back and then filing the extension. Otherwise, you can wait outside the US until it gets approved, come back in on your valid visa if they've not expired, or go for stamping while you're outside the US.
Pani Ganta has this question. My GC EAD is approved. AP extension is still processing. Can I go to Mexico and come back? My main question is that, what are your plans to come back? On the GC EAD, you cannot come back into the United States. No, no, no. So if your current advance parole is valid, let's say, for example, your current advance parole is expiring in March of 2024, and you're planning to go to Mexico and you're coming back before the expiration of the advance parole, even though you have an extension pending, I don't have a problem because you do have an advance parole until March of 2024. But if your current advance parole expired and you don't have any visa stamping, let's say H1 or L1 for which company you're working right now, no, you cannot travel on the GCEAD alone.
Shaylander says, I have valid H-1B stamping until February 2024. My extension is already approved until 2026. Can I travel to India in January 2024 and come back in January before the current stamping expires without going for stamping? Yes, absolutely, you can do that. And when you're coming back in, you can show your extension approval to get that, make sure that you get your I-94 till 2026, because sometimes they will mistakenly only give you the I-94 till February 2024, and that trumps the I-94 that you were given on your extension. So make sure that they give you the correct end date when you're entering, but your visa is still valid. You can still use it to travel up until it expires.
Anup is asking the question, can I apply the I-485 after the approval of the I-140 on national interest waiver? Well, your priority date has to be current. We have done some sessions. What is the priority date? You may want to look into it. We may do a couple of sessions on it. What is the priority date? How to look into the priority date. But yeah, your priority date has to be current. I don't know if you are from India. If you're from India, it's backlogged all the way to 2012. National interest waiver does come under EB2 category. It doesn't come under EB1 category, though. So EB2 category is backlogged all the way. Let me read it out for you. That is, the filing dates is actually 15th May of 2012. So if your priority date is before 15th May of 2012, then you can file the 485 right now. Question is, go ahead.
David from Facebook says, can I know the status of issuing GC, EAD, and AP for people who got their I-140 approved 5 years ago? So this was the White House Initiative on Asian Americans, Native Hawaiians, and Pacific Islanders, this organization that is meant to advise the president, they came up with their recommendations, and this was one of the recommendations that they gave a few months ago to the president. We have not seen the president act on that recommendation yet, but how can you find out about what's going on? They actually have a newsletter for this WHIAANHPI organization. So if you, and I'll try to put this in the comments somewhere, I guess, you can go to hhs.gov and then find this White House Initiative on Asian Americans, really long title. And then there's a little button to click that says sign up for their newsletter. And then you can mention that you want to know about immigration and citizenship and subscribe. That's probably going to be your best way. And then you can actually reach out. They have their contact information there as well. So that's kind of the status right now. Not as far as we know, no action has been taken, but definitely we do have on immigrationgirl.com, we have a letter writing campaign that you can copy and send to try to get them to grant that EAD and AP for those that are stuck in the backlog.
Agrim Rocks has this question. His passport is expiring before his advance parole expiration. Is that a problem? As long as both the expirations are not expired, if, let's say, for example, the passport is expiring in April of 2024 and your advance parole is expiring in June of 2024, but if you're returning before April of 2024, I don't have a problem. Now, we haven't seen cutting down the I-94 period or anything for advance parole. I don't think so they can. But anyway, just check the I-94. I don't think so they can, but just check the I-94 before, as soon as you come into the United States. Another gentleman has this question. My daughter is going for H-1B stamping. When she comes back, she wants to use the H-1B. She does not want to use the advance parole to travel into the United States. How to make sure at the CBP, that is at the port of entry, that the H-1B is recorded? Well, don't show the advance parole. Keep it in the pocket, right deep in the pocket. Just show the H-1B, which is valid. The person is working. They may ask, do you have a pay stubs? Show it. Don't show the advance parole. That's it. You're good. Normally, you will not face any problem. Now, even if they ask you questions, you have an advance parole, also you can tell them, but no, they will still give you H-1B. We have never seen that problem anywhere.
Mohammed says, my I-140 is approved, EAD is approved, but AP is still pending. Currently on H-1B and have my 485 current. So the question is, can I travel to my home country while my AOS is pending? So there is a special rule specifically for H and L holders that does allow you to travel without the advance parole and not affect your pending I-485 as long as you have a valid H or L status at the time you leave and you're coming back on valid H or L status. So I'm assuming that you have a valid H-1B visa stamp. So as long as you have that, yes, you can travel without getting the advance parole and your 485 remains pending. That's not true for any other visa category, only H and L.
Emily, Chandrakant Rajapurohit has a very interesting question that requires your attention and a little bit debate on this question, though. When most of the H-1Bs and L1s are from India, under which visa category is this rest of the world demand coming from? Very good question. Now, let me tell you one thing. 60% of the H-1Bs are Indians, but 40% are not. Now, there are 65,000 plus 20,000 master's category and plus up to 20,000 to the exempt category. Now, even if it's not 20,000, it's at least 15,000 for the universities and nonprofit organizations that qualify for it. So total of approximately 1 lakh H-1Bs are given. If 60% of them are Indians, what does that mean? 40% is left to rest of the world. That means 40,000. Now, is 40,000 40,000? No. The law, in law school, they don't teach us proper mathematics. 40,000 means not 40,000. 40,000 means 100,000. Oh, how does that sound to you? 40,000 means 40,000. No, 40,000 means 100,000. Now, the reason is that we don't count the family members in the green card. You see the point? Now, 40,000 is coming 100,000 is coming to 100,000 because you have to count the family members. Now, not every person who is an H-1B will apply for the green card, but I will get there. Those many people can apply for the green card. So that's where the rest of the world. Then L visas. Even if most of the visa people are from Indians, the non-Indians constitute some number and their spouses constitute some number. They can get the green card. And then there is another category called TN visas. You know what TN visa is? This is only for the Canadians and Mexican nationals, though. Since their priority date is not backlogged under some limited conditions, they can apply for the green card and get the green card from there too. Now, these are not the only categories, guys. Let me tell you some of the other working categories. O visa, P visa. I covered T visas, right, Emily? O visa, P visa. They both come under the employment. They can come under the employment based. Oops, don't forget E1, E2, E3 visa. They also come into the employment based categories. Now, the people, and now I just told you some of the working visas that can come in. But let me tell you though, what if the person is on student visa, F visa? Can the person who is on a student visa, rest of the world guy, can they directly go to green card, circumventing the H, T, O, P, E visas? Yes, they can, because nowadays you have an OPT for 1 year, plus you have a STEM extension for 2 years. So in this 3-year period, if he gets the labor certification approval, then when I'm reading the priority date of the EB2 and EB3 for the rest of the world, it's February 2023. We don't have any labor certifications filed in February 2023 approved. So practically, the person can move from OPT directly to green card. So these are the numbers that I can cover right now. But if you allow me 1 hour, I can cover a lot more non-immigrant visas who can be converted directly into green card. Under some limitations, B2s can be converted to those things too. F1s, J1s. I forgot about the J1s. And so many. A visas, maybe not. B, under some limited conditions. C visas, not. D visas, not. E visas, E1, E2, E3 can. F1s, G cannot. Lot more, Emily. I don't want to go. I's can. I visas can. Yeah. I don't want to take a lot of time. Let's get it.
All right. Rana says, I have a valid I-797B from an H-1B lottery picked in 2020, but it was never stamped. Traveled to the U.S. on H-4 in 2023. Can it now be transferred to H-1 status if an employer is ready to sponsor? Only if the original employer that got that visa, the H-1B approval for you in the lottery files it. So basically, when you get that I-797B for consular processing, there's no I-94 attached to it, and you don't actually get that visa stamped based on that approval notice, you have not been counted in the lottery yet. So you're not counted in the cap based on getting selected, your registration selected. You're not counted in the cap yet, even though you filed the H-1B. You're not counted in the cap yet, even though you got approved. The only thing that makes you counted in the cap is the I-94 actually putting you in H-1B status or getting that visa stamped at the consulate. So since neither of those happened, you're not counted in the cap. So another employer cannot take advantage of that H-1B approval. But if the original employer is still available and has a job offer, they can file a change of status to H-1B for you. Once you get that approved and you start your H-1B status, then you can transfer to any other employer going forward.
Does the office evaluate EB2 NAW process? Yes, we do. And the best lawyer for that is Rebecca Chen. And for EB1A guys, it is Kareem from our office, though. Please try to pick the proper lawyers. When you go to the consultation, we give the details of the resume. But if not, you can always send an email to info@rnlawgroup.com. We'll recommend who is the best lawyer for which category, though. One question that is coming out, Strayas, man, he comes with beautiful questions. Question of the day today. When does the 365 PERM PERM delay start from? I mean, so that he can file a 6-year extension, though. Does it start from the time prevailing wage has been filed, or is on the day the PERM application has been filed? Unfortunately, Straya, the answer is not the prevailing wage, but on the day the PERM labor certification is being filed, the 365-day counts. Unfortunately, that is the truth.
Baby says, I'm an L1A holder, but I have one reportee. I do performance reviews, but do I need to manage more than one? I have 5 indirect reportees. So I'm assuming this question is for qualifying for EB1C. So it's possible to still qualify for EB1C with only one direct report. It can make the case much more difficult to be approved, but what you may want to look at is, can you also qualify as a functional manager? In that situation, the people reporting to you are not as important. It's, are you in charge of a particular function of the company? Is that function essential or critical to the company? Do you operate at a high level with respect to that function? And do you have authority over the day-to-day operations of the function? So that is another way that you can still qualify for EB1C, even if you don't actually have, if you're not a people manager, you don't have people reporting to you.
Emily, I know the answer, but I just want to make sure that I'm answering correct, though. If the reportees are in India or outside the country, do you have a problem with it?
Not at all. Do those all the time.
Okay, let me explain.
I've had one RFE on that issue.
Go ahead, Emily.
I was going to say I had one RFE on that question, but we were able to get the approval because there's nothing in the statute or regulations that specify where your reports need to be.
Let me understand this, Emily. I have 2 reportees here in the United States. I have 20 reportees in India. It's fine. You can count those 20 people. What if I have 0 reportees here, but I have 40 reportees in India?
Still fine.
Oh, that's just want to let you know. Question that is coming is, we are the most of the Indians paying fees, revenue generated, buying houses, paying property taxes. Why, why so many heavy backlogs for Indian nationals? Well, that's exactly where I am telling you is the problem. Indians are making lots more money. Their average income is double than that of the national average in United States. They are probably 50% more than any other ethnic group in making the money. They are buying luxury homes. They're paying good taxes. They're very good taxpayers. In fact, Georgia congressman says Indians tend to pay 6 times the tax of normal people because as the income raises, the tax raises. For the first $50,000, there's absolutely no tax. Now, after that, the tax come in. But where is the problem coming in? That's the problem. You guys don't complain. You are telling you have so many luxury homes. You don't tell that you deal with us. You don't tell us that so many bad things happens when you go through the immigration. You don't tell them every time you travel, you have to get the permission. You don't tell them how difficult it is when your kids don't get into medical admission because they don't have a green card. All you tell is that you make $500,000, you live in $1 million home, and you drive a Ferrari car. That's not how the congressman will get convinced. Get them to know the other side of you, that you deal with immigration, which is very tough for you. You deal with every time you travel. Your kids getting admission because they are not green card holders is a big problem for you. Tell their problems. Don't show your assets. And write the letters every time we tell them. Sorry.
Oh, no, that's... Tarun says, I'm filing for L1A and he's currently in India. What is the current time frame for approval, or should I go with premium processing? For your first L1A, L1B as well, I file all of mine in premium processing. I don't mess around with regular processing. even though they say the processing time is 2.5 months for an L1A, that's the processing time for 80%, which means 20% take longer. And those 20% always happen to be mine for some reason. They take 6 months, and then I get a lovely RFE. That takes another month to prepare the response to, and then we respond, and then it takes another 2 months after that. So you're looking at 8 months standard for regular processing. Just go with the premium processing. I know people say you get more RFEs and a higher rate of denial. I'm not seeing that. And it definitely is major time saver.
What will happen if someone changes the end client while PERM is in progress, filed but not approved? Not a problem at all. You're working for a consulting company. Let's say your end client is Coca-Cola, and now all of a sudden, no, it's not Coca-Cola, it is Pepsi. Not a problem. Not a problem for your labor.
Mr. Crazy Frog says, will I lose my H-1B status if I travel outside the U.S. and then return back on my AP instead of H-1B because my H-1B visa is expired? You will not lose your H-1B status. So you can return on AP, and if your H-1B I-797 with the I-94 has not expired, you can consider yourself to be an H-1B status. You can continue to extend the H-1B. You can file a transfer. You can treat it as if you're still an H-1B.
Can the H-1B holder start a YouTube channel? Yes, you can. However, to monetize it is a different issue. If you want to monetize it, that may not be permitted based on the H-1B because you're technically working. But if you have a hobby, let's say, for example, I used to be running coach. And that's just a hobby. Nobody paid me. So is that okay to be running coach on H-1B? Absolutely, yes. You can do your hobbies, but if you want to make money on it, though, that's when the problem comes in. You must have a work permit to have it. Is it safe to travel back to India and get F-1 stamping done while on day one CPT? That's equivalent to committing suicide. No, it's very tough to get the stamping. Even if you get the stamping, there's a chance that you may be thrown out at the port of entry for the day one CPTs. We don't consider day one CPT universities as legal universities. I know we sound odd when we said multiple filings are illegal. They're not good. They may get into trouble for you in the lifelong. That's according to law. We are stating it. Because think of this thing. There are 3,000 educational institutions. How many educational institutions are issuing the day one CPT? 5. I can name some of them. Cumberland, Campbellsville, Harrisburg. Now, why not the rest of the 2,995 universities are not giving? One reason, you can sense that. Now, I will also tell you that there are 2 university officials, the presidents of the organizations, who are in jail still now because of issuing a day one CPT. I will name those universities. Silicon Valley University, Tri-Valley University. Now, there are 2 universities that were a sting operation. What is a sting operation? Means the USCIS pretended they are the universities and spoke with the kids and admitted them where they never studied. They got their day one CPTs. One is University of Northern New Jersey. One is Farmington University. Now, please note down all these 6 universities, these 4 universities that I noted. You can Google it. You'll find all that information. So that's the reason why we're telling is that all these things may get into trouble in the long run. We do not recommend day one CPT university. Can I rent my home on H-1B? Not a problem, Swati. You can rent.
All right. Well, I think we are out of time for today. Thanks, everyone, for joining us. And we will be back next Tuesday at 5 o'clock Central Time to get your questions answered. Don't forget, we do have a daily conference call that's free that you can join, get your questions answered there, speak with one of our immigration attorneys. And you can always set up a consultation with us or any of our attorneys by going to rnlawgroup.com.